Welcome to Class 5 for the Mr. Cannabis Law coursework. Today we're going to be talking about real estate. Real estate is huge in the industry. Every single operator needs real estate, whether it's cultivation, processing, dispensing. You're going to need to acquire real estate, and there are a lot of challenges. Do not use standard templates when you're doing a real estate deal. Do not use standard templates when you're doing a real estate deal. Make sure that you have very specific provisions that account for some of the complications in some of these real estate deals. So the key topics that we're going to be going over today is that selling and leasing real property to marijuana business is very, very complicated because of federal law. And really it's banking challenges. That's really where federal law comes into play, is the banking challenges. So banks cannot accept money from illegal businesses pursuant to federal law. So that becomes very, very complicated when you want to pay a landlord their rent, and that landlord needs to accept that money within their bank. If it's coming from a federally illegal business, that bank should not be accepting that money. Also, mortgages. Banks that are FDIC insured, right, they're going to have provisions within the mortgage documents that essentially say that no illegal activities can be conducted on the property. So really, you would be in violation of that mortgage, and a landlord that owns property with a mortgage, if they leased to a marijuana tenant, they would probably be foreclosed upon by their bank. So really, these marijuana companies have challenge because when they pay their landlords, their banks are not supposed to accept that capital. And then also the mortgage side of things, really that landlord should not have a mortgage on that property. So that's very challenging to find a landlord that owns property with no mortgage on it. So marijuana businesses and residents who consume marijuana need to be aware also of anti-drug lease provisions that are common in states with an established marijuana industry. And then we're also going to be going over marijuana business have several obstacles to overcome before modifying a leased property. And then finally, landlords and businesses must balance the landlord's right to inspect with the state's marijuana laws, right? So the landlord is generally going to ask for a right to inspect property. In any non-cannabis lease, you're going to see that, but certain marijuana laws may prevent that, and you want to account for that within the lease agreement. So moving on to the next slide, what we're going to talk about is owning and the leasing risks. So under 21 U.S.C. 856, which is known as the crack house statute, this is a federal statute, it is illegal for banks and landlords that provide marijuana business with the ability to manufacture, store, distribute, or use a controlled substance. As we've gone over in a lot of the previous classes, marijuana is a Schedule I controlled substance. So essentially, these landlords and these banks would be violating this federal statute. Landlords also cannot rent property to marijuana businesses under federal law. Banks cannot provide marijuana business with mortgage loans or accept rent payments a landlord collects from a marijuana business, like we discussed. And then banks and landlords that violate the statute are subject to civil and criminal penalties. That's very important to be aware of. Banks and landlords that violate the statute are subject to civil and criminal penalties. And that's why when I have these lease challenges, I've listed a bunch of them, and one of them I have in here is indemnification provision for the landlord. If you are representing a landlord, you want to make sure that that landlord has a provision in there that they will be indemnified if the federal government comes after them, both criminally or civilly. So that's a very, very important provision to have in there. So landlords are also hesitant to rent property to marijuana business because of the smell, the potential theft of cash on the property, moisture issues, and fire hazards. So really, because of these risks, what you end up seeing is that these marijuana companies end up paying very high cap rates for their leases. Generally, you're going to see them anywhere from 12 to 15%, which is much higher than the standard tenant. So be prepared. If you are representing a marijuana company, you need to be prepared to explain to them that they're likely going to have to pay a much higher rent rate because they're operating a marijuana business and because of all these issues we just went over. And if you're representing a landlord, you want to make sure that they really understand those risks of renting to a marijuana tenant. So moving on to the next slide, what we're going to go over is the anti-drug lease provisions. And mainly this has to do with not the business side so much, but on the residential side. So if you're leasing a home or an apartment, and there's generally within that lease going to be a provision in there that you cannot consume illegal products on the property. Even if you have a medical marijuana card through your state, remember, it's still federally illegal. So these anti-drug lease provisions become very complicated. We're seeing more and more issues with tenants that are looking to consume marijuana on the leased property, but they cannot. This also becomes an issue with a lot of the HOA. A lot of these HOAs have certain items in their bylaws that basically says you cannot consume illegal compounds. So if you're representing an HOA in this particular situation, you want to make sure you go through those bylaws and you have specific language that accounts for these issues. So moving on to the next slide, what we're going to go over is property modification. So any property used by a marijuana business will need to be modified unless a marijuana business was leasing that property previously. And the reason for that is that the statute has all sorts of requirements. So generally you're going to have a different secured area for visitors in a dispensary facility. You're going to have to install proper air filtration equipment. You're going to have to change the materials used inside the room of an industrial property to comply with CIDI requirements for all marijuana manufacturers. And you're going to have to expand cultivation facility to add additional grows. So constantly these marijuana companies are looking to modify that property. And when they go to modify that property, generally the lease is going to not only require them to ask the landlord for approval, but it's also they're required by state to ask for approval if it's a material change. So very important that you deal with that. So some of the states will also require marijuana operators to submit that approval to a marijuana regulatory authority. So within this lease agreement, you really want to make sure you account for any sort of property modifications. So property modifications, air filtration, security, all these things need to be accounted for right in that lease agreement. So moving on to the next slide, what we're going to discuss is the inspection rights. So a landlord, if you're representing a landlord, they're going to always request the right to inspect the property from time to time, right? A landlord wants to know what their tenant is doing, if there's an issue with a pipe or there's a flood or something bad is happening to the property. The landlord owns that property, so they want access to that property. They want the right to inspect it. But in all states with an established marijuana industry, the goal is to have a detailed account for each visitor and to limit the number of visitors to a marijuana business in areas where marijuana is stored. So what you see in the marijuana regulations is that there's certain restricted areas within marijuana facilities that are only allowed access for people who are actually employed by the marijuana company. So how do you balance this, right? The landlord wants access, but the landlord is not an employee of the marijuana company. The state statute doesn't allow you to provide access to non-employees. So when you draft this lease agreement, you need to include very specific provisions. And some of the general provisions you want to put in there is that the landlord must provide advance notice of inspection. So at the very least 48 hours, but sometimes we see even 10 days, 15 days, 20-day type notice. Obviously, if you're on the landlord side, you're going to want to try to reduce that amount. If you're on the tenant side, you're going to want to increase that amount of notice. You're also going to want to say that inspections that occur a set number of times per year, so maybe semi-annually or something like that. And then only the landlord or any legal representative of the landlord inspects the property. But with all these provisions, what's very important, you need to look at the specific state statute that addresses this, because you need to make sure that the provisions you draft relating to inspection and access for the landlord are consistent with the statute allows as far as people getting access to certain restricted areas of that facility. So moving on to the next slide, what we're going to talk about is just the do's and don'ts. We went over a lot of different material. These are some of the different challenges with the leases. We went over anti-drug lease provisions. Illegal activity provision is generally in a lease. That we didn't talk about that yet. That's very, very important. So we talked about this one. Illegal activity. Most commercial leases will say that the tenant is in breach of their lease if they conduct any illegal activities. Well, the tenant is conducting a federally illegal activity. So it's important that you have some sort of addendum or you change that language to specify that what they're referring to by illegal activity is referring to things that are done illegally from a state perspective, but not from a federal perspective, because otherwise the tenant would be automatically in breach of that contract. So we went over that. We went over the property modifications that you want to go over. Inspection access rights. Odor, we didn't go through this. So odor is a huge thing. So if you're leasing property, right, I mean, you got to comply with your lease. But even if you own property, so if you own property, you don't have to worry about a lot of this stuff. But if you own property, what becomes a huge issue is this odor. And it becomes an issue in a nuisance lawsuit. And we're starting to see more nuisance lawsuits where neighbors of these marijuana companies are starting to see that the odor is percolating into their property and therefore causing a nuisance. So you're starting to see some lawsuits as it relates to that. Something to really keep in mind, especially if you're on the landlord side, if all of a sudden you're getting sued because the smell of the marijuana is starting to percolate into the neighbor's property. We went over the indemnification provision for the landlord. So you want to make sure that if you're representing a landlord, there's some sort of indemnification provision that accounts for the fact that federal law makes it illegal for the landlord to do this, and there's criminal and civil penalties, and really the tenant should be on the hook for that to indemnify them. And then one other thing that we haven't touched on is the licensing contingency. What happens in a lot of these real estate deals is that if you're representing someone that is applying for a license, right? They're applying for a license. They don't have a license to operate yet. Some states require that in that application, they identify that they own or lease a specific piece of real estate. Some states don't require that you own and lease a specific piece of real estate. But imagine if you're representing a client and you're applying and they're spending hundreds of thousands of dollars on hiring you to apply for a contract, but within, or for a license, but within that application, you need to identify real estate. So what are you going to do? You're going to go out and you're going to find a landlord or a piece of property and you're going to negotiate a deal. And oftentimes these are done as letters of intent, right? You don't want to fully commit into a lease because you don't have a license, but you want to make it contingent on obtaining the license. So just to give an example, in Illinois, they have retail licenses, right? So retail licenses are separate from cultivation licenses or craft grow licenses. For the retail license, no property had to be identified. So all you needed to provide was just a drawing of what the dispensary layout would look like. That's easy, no real estate issues. But on the craft grow side, what they required is you actually identified the piece of property and you showed that you got approval from the local zoning authority. So you had to go find property before you even had this marijuana license. You needed to lock down that property. And those applications in Illinois for those craft grow licenses were in January 2020. They were supposed to basically decide the winners in about June 2020. But what happened is there was a bunch of lawsuits, and now standing here today, we are in July 2021, and they still have not issued licenses to any Illinois craft grows. So for people who are not well represented by a good attorney in Illinois and that got sucked into entering into definitive leases at high amounts with no licensing contingency, they've basically been stuck paying for a lease since basically January 2020, and they still don't even know if they have a license. So some of these are just some of the many challenges that you're going to face with real estate. So very important, if you're planning to practice real estate law within the cannabis space, you not only need to be great at real estate, but you also really need to be familiar with the different issues that are within each of your respective states. So I'm going to go over the do's and don'ts. So do be aware that marijuana businesses will need to purchase a property outright with cash to provide itself the greatest opportunity to acquire the property and to make all necessary changes. So the ideal situation for your client, if you represent a marijuana company, is just to own it outright. So you don't have to deal with some of these illegal activity provisions in these lease agreements, the indemnification provisions, licensing contingencies. Really, if you could own the property, your client is in the best position. Obviously, that's more expensive, so it's a cash thing. Be aware that many landlords do not allow any use or possession of marijuana. So in addition, both residential and commercial leases can contain anti-drug lease provisions. So if you're if you're representing an HOA, you want to take a look at that anti-drug lease provision to see what they're allowing these tenants or these owners to really do. Remember that the landlord-tenant relationship between a property owner and a marijuana business will be different than most commercial landlord-tenant relationships. So you really need to make sure you're not just using standard forms. That's probably the biggest mistake, and I see it all the time with some of these cannabis companies, is just entering into these standard templates. They do not work for the cannabis space. So don't forget that the banks and landlords face significant risk by allowing cannabis businesses to lease and purchase real property. So you're generally going to have trouble getting any sort of bank on board to deal with any of that stuff, and you're generally going to have indemnification provisions in there as well. Don't sign any lease agreement that contains anti-drug provisions if you believe you're going to violate it. And don't allow a landlord in a property lease agreement to enter the marijuana business premises more than allowed by that particular state statute. Those are things you need to be very careful about. So we went over a lot of stuff today. Obviously, we just touched on some of the very basics of some of the issues that you're going to see in practicing real estate cannabis law. But hopefully you go back to the course materials and really dig into them, because there's a ton of information within those course materials. We get into great detail of all this. You're also going to find more sample provisions that you're going to want to put into a lease agreement. So definitely go back and look at the coursework, because there's really a ton of very detailed information relating to real estate cannabis law. So thank you guys so much for joining this class, and we look forward to seeing you at the next one.